Okay, Assalamualaikum and hi everyone. My name is Normalia Shafika binti Abu Nu'man. My matrix number 1968227. So today, me and my teammates Shakira and Ihsan will be present about our finding on the case of insurance LTD versus Owens Corning. Next slide. Okay, so I will start the presentation with the facts of the case. First, XL agreed to insure Owens Corning and its subsidiaries against property damage and associated risks. Next, the contract was negotiated and effected on Owens Corning's behalf by a broker in the Bermuda branch of Marsh and McLennan, acting as Owens Corning's agent. Then OC decided to have a single worldwide program of property insurance, and then emailed XL Property Division asking if XL would be prepared to write a proportion of the risk. And then XL replied that they would be happy to issue a quotation once the policy wording had been finalized. Next slide, please. Okay, then OC emailed XL saying that Marsh had a conditional order to bind coverage with effect and setting out various conditions that need to be met prior to binding, and then XL willingness to provide coverage in accordance with her previous indication, and then XL chased OC for a copy of Allendale's policy in order for XL to be able to issue its own formal policy. And the last one, the policy document stated that it followed the Allendale Spectrum policy number NB105 up to a limit of liability in respect of each occurrence of 10 million. And I'll pass the presentation to the next presenter for the importance of the case. Thank you.
Okay, so Assalamualaikum, and today I would like to present about the importance of the case. Okay, so the first one is there are conflicting decisions of the United States Court of Appeals for the different circuit on the question whether the written contract containing arbitral clause has to signed by both parties or contained in an exchange of letter or telegrams. And then the second, on 17 March in 2000, Owens Corning began proceeding in the Superior Court of the state of the Delaware against XL for the declaration that XL are liable to indemnify Owens Corning for certain costs. And then next is from the evidence that any United States court faced with an application to enforce an international arbitration agreement must apply the FAA regardless of any choice of law by parties. And then the last one, therefore, the arbitration has an important role in terms of solving disputes of insurance claim. Okay, so that's all from me. Next, I will pass to the next presenter.
Okay, I will continue with the decision of the case. So, Owen Corning argued that the apparent arbitration agreement in the Bermuda was formed unenforceable because the requirements for a valid arbitration agreement under New York law has not been met. So before that, we would like to outline that the convention definition of agreement in writing to include either first an arbitral clause in a contract, or second an arbitration agreement which signed by the parties or contained in exchange of letters or telegram. So next, Owen Corning called expert evidence in effect of Article of the United States Federal Arbitration Act, and then United States Code Section 1, which incorporated the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards 1958 under the term the conventions. And after that, they set out the requirements for recognition of an arbitration agreement, and then the requirement that the agreement should be in writing, signed by the parties, or contained in the exchange of letters or telegrams. In accordance with the convention, there was no valid arbitration agreement. The formal requirements for the existence of a valid arbitration agreement under Section 5 of the English Arbitration Act 1996, which is less stringent than those under the convention. Next. So the English court was asked to decide whether the arbitration agreement was to be interpreted by the reference to English or New York law. So the previous authority to the effect that in exceptional cases the law applicable to the interpretation of the arbitration agreement within the contract may be different from the substantive law applicable to the parties other obligation under the contract. So Owens Corning's main submission is the issues can in any case determined most justified and conveniently by the court in Delaware by applying US federal law than by this court or by London arbitration. So no prejudice to XL in the issue being determined by the Delaware proceeding against XL as stay because Owens Corning wishes to be able to proceed all the relevant insurers in the same action. Therefore, there is no justification in principle or on the balance of convenience for the grant of an anti-suit injunction to prevent Owens Corning from pursuing a claim against XL in Delaware. So in conclusions, the party's choice of procedural law under the Bermuda form, i.e. English law, also applied to the interpretation of the arbitration agreement. Therefore, Judge Townsend has decided that under English law, there was a valid arbitration agreement, and on that basis, he granted the injunction. That's all from us. Thank you.